Hi, Julie. Welcome to the Resolution Room.
Thank you, Damien. It's a privilege to be here.
Well, before we talk about what I want to drill down with you today in terms of your trauma-informed approach to mediation, your work as a mediator more broadly, let me do this by way of introduction. One thing I've really loved about my pivot into mediation has been getting to know other mediators in the national community. And your name jumped out at me and we've had some connection and particularly your approach to trauma-informed mediation and your very niche work. And I guess also you're a fellow traveller in terms of being a former solicitor. That also was of interest to me. You've been in 2022 the Mediator of the Year award through the Australian ADR, and you've been in Doyles for the last 5 years as a recognised mediator in the very well recognised and well regarded mediator in the New South Wales market. Have I done that justice by way of an intro, Julie, before we get down a bit deeper into your backstory?
Absolutely. I do like the fact that we are fellow people pivoting out of legal practice and into mediating as a profession. So when we had our chat, it must have been 18 months ago now, it was great. We shared a lot of common approaches, ideas and philosophies around mediation.
I think you were at Phillips Fox Meridian. So you're working in a defendant practice predominantly for many years. And what then drew you initially to mediation, Julie?
Yes, defendant practice primarily, but throughout my whole university era, I was working as a paralegal in a plaintiff's practice. So I did have a bit of a plaintiff's perspective, moved into defendants. I decided to move into mediation pretty much as a result of how I was seeing mediating taking place post the Royal Commission. So a lot of the work, particularly when I was at Meridian and to a lesser degree at Phillips Fox, I was doing medical negligence work, but started building up a practice around civil claims arising out of historical child abuse. And there were a lot of traditional approaches to mediation, i.e., ex-judges, barristers moving out of practice at the bar or bench and deciding to mediate. And all of them approached it in the way that mediation used to be done. It was very much let's explore what's happening, sound each other out, not go much further. It was very lawyer-driven. I had a client that was heavily involved in the Royal Commission, and they were very passionate about having a very victim survivor focus towards the legal process, but just didn't quite know how to do it. My undergraduate background is psychology, and since finishing as an undergraduate in the psychology space, I kept reading. It was just fascinating. I'm a bit of a psychology nerd. I've read way too many books on psychology. So for me, it was natural to try and bring what I intuitively believed was an approach with dealing with people with trauma. And when I say trauma, I was doing it initially in a medical negligence space, but the post-Royal Commission, it really ramped up. And there was one particular claim, and I had one very good client that was happy to accept my suggestions around, let's do a joint medical report. Let's not subpoena every single piece of background material to do an in-depth, detailed analysis of all of the nuances of heads of damage. We obviously did it in a way that gave everybody a good approach and a good understanding of the liability risks and quantum risks, but let's see if we can truncate it a little bit. And the response we had from the plaintiffs and the defendants at the same time was remarkable. I had one lady who had a very long history where she had kept her abuse experience private for 50 years because it was a friend of her father. She didn't become ready to disclose until after her father passed away. She said to me at the end of the mediation, everybody told me that you were going to be really mean to me, but you've actually made me think that people aren't that bad after all. And for that, for me, it was a bit of, we can still be lawyers. People can still be lawyers, but do it in a way that's not going to re-traumatise and have some steps towards creating an environment where people may start to feel that they can take steps to rebuild their lives or start that healing journey. So at that stage, I thought, I really want to make this a career choice, probably as a way of trying to bring about cultural change more than anything else. So it was a very deliberate step to make a career decision to become a mediator for my next career chapter rather than being somebody who's just transitioning into retirement.
I've spoken to other mediators about that, in not so much through the lens of institutional abuse and trauma, but very much resonate with the idea that this was a skill set that I was going to devote the next 20 years of my professional life to, as opposed to, as you say, that sort of winding down phase. I certainly didn't want to see it like that, and I don't see it like that. So that's a really interesting story. And so it drew you into this world, and your practice now for R3 resolutions is principally in sensitive sexual abuse matters. Is that right?
It's not just sexual abuse. That is a big portion of my practice, but it is all sensitive and highly emotional claims. So I do a lot of birth trauma claims, a lot of compensation to relatives, death claims, nervous shock claims out of catastrophic events. So it's one where there are big emotional elements to it. I don't do family provision and claims and family law claims, which obviously also have a huge amount of emotion.
Yeah, of
But
course.
I'm in that civil space of anything that's very high emotion and sensitive. So it involves that real interpersonal interface between the resolution of a claim in a legal framework, not bringing in full restorative justice approaches, but sort of trying to merge the two.
Merge the two and bring about, as you said, a level of cultural change. Now, you've been in as a mediator, was it 7 years or thereabouts, Julie? Am I right? 7
Yeah,
or
I
8
think
years?
it's about 7 years, I'd say. Yeah.
What did you think of the accreditation and the training process?
As a mediator,
Yeah. Yep.
I did my training through the College of Law, but I'm a member with the Resolution Institute. Look, I think comparatively to on a worldwide scale, because I have had the opportunity to speak to people around the world, I think we get really good training, but we are trained in a facilitative model. And a lot of the way that civil claims are mediated is not a facilitative model in its pure sense. But the facilitative model that we are actually trained in is a really good foundation. I've had a few claims that have come out that I've dealt with, mediated, that have been almost workplace disputes. And I'm not a workplace mediator, but for various reasons, I've facilitated some in that workplace setting, or even some dissolution of small businesses and partnerships, which is actually surprisingly emotional. A lot of people might think resolving a business is not, but it's fraught with emotion. So I do have done a few of those as well. And those I tend to really adopt that pure facilitative model because two individuals really need to be able to speak directly to one another. A civil claim with a plaintiff and a defendant, there's rarely an ongoing relationship, so you don't need that pure facilitative model.
Yeah, my reflections are similar. I think it's quite prescriptive, but probably a good foundation. And certainly in the workplace space, I draw on those skills a lot more. In the traditional litigation injury space that I mediate a lot in, it's quite different. You draw on some of the same skills, but I guess from a perspective of an education point, and having regard to the broad spectrum of mediation, particularly a lot of people in my course who are in the family law, it is a good foundation, and you've got to start probably from that purist model. But yeah, it's not something that necessarily is, mediation is such a broad spectrum of work, isn't it?
It is. And it's also, as a mediator, I think you have to have a broad range of skills because not every claim needs to be handled and mediated in exactly the same way. So I've recently completed a workshop on a more humanistic approach to mediation, which is very different to the way that the facilitative model we trained in, but it brings you some incredibly good skills to be focused on being very present with a claimant or a defendant whilst they are in the process of unpacking what they need to unpack and rebuild to actually get to a resolution. So I always encourage mediators actually to keep being open to being exposed to the other models of mediating as well. So certainly, whilst I wouldn't be adopting a purely humanistic approach to the mediation of matters I do, there is some huge amount of value in some of the skills that I learned at that workshop.
Yeah, I think that's a good reflection. I've certainly intending to draw on other training across other fields as well. Let's go to this because it was a driver for you in where you are now, the trauma-informed approach. And I guess before we drill down on what that is and what that isn't, and particularly having regard to your background in psychology, let's talk first about what is trauma and how it shows up in a neurobiological way for individuals, how it impacts people and why it matters in terms of decision making.
Sure. I will go very high level because there are incredibly expertise that have this is their whole work. So, at a very high level, trauma is the impact that somebody's experience of an event has upon them. So, that can be different for everybody. Somebody can go through one event and have a very different physiological, psychological reaction to somebody else. So, the trauma is actually the impact upon the individual's body and brain. It brings into play, on a very simple level, when somebody is faced with a threat of some kind, and it doesn't need to be a physical threat, it can be a threat to their sense of safety, their sense of their reputation, their financial position, their physical position, all of those things. The body's initial protective mechanism is to use that fight-flight mechanism. So that part of the brain that is, people talk back in the day of when you're being chased by a bear in the woods, that sort of thing. We don't have bears in the woods when we're walking around a law office, but we may have somebody, a client or somebody approaching us that gives us that same physiological response. So needing to be aware that somebody is, if they're in that fight-flight sense, is not able to use the thinking part of their brain to full effect, their prefrontal cortex, that can impact their decision-making ability, their ability to listen to advice that's being provided to them, their ability to make informed and rational decisions based upon concepts that are often very foreign to most people. Talking to somebody about what a duty of care looks like, or most recently, what non-delegable duties involve. All of those things are very hard for somebody to process if they are focusing on self-preservation and protection. So it's about trying to balance and maximise the ability for people to be in a position where they can draw on the thinking part of their brain most effectively.
Thank you for that very high level. I see that come across in your work. So having regard to what we know about trauma and how it impacts, and you're right about the vagaries of the impacts on individuals is quite different. And you see that in so many areas. What is a trauma-informed approach? I mean, I've read some of your work. I do read your newsletters and other work, Julie. I'm really interested in it as well. So you've said, for example, it's not therapy, but it is really making allowance, effectively, as I understand it, for a space in which you can encourage the level of thinking and decision-making required. And what does that take from a mediator? And what does it take from the perspective of the parties in the process?
I like to try and explain a trauma-informed approach to mediation or claims resolution as thinking of it as a way you design the process rather than being there as a therapist to take somebody through settling their claim and what that psychologically could mean for them. So there's some general principles around what involves trauma-informed approaches. Now, often this starts off in the context of therapy or working with people who are directly experiencing, but it's focusing on making sure people feel safe, that they trust the people that they're dealing with, that they feel that they have a sense of control, that they're empowered to make decisions and they can collaborate in the decision-making process, whatever that may be. So as a mediator, what it entails for me is actually at a very first step is making sure I am 100% present with a particular claimant. My reading and preparation beforehand, I will be looking as I'm reading through the materials for any examples of triggers, things that I feel that potentially may be of concern or agitating to a claimant may push them out of this concept of what's called a window of tolerance, and trying to make sure I preempt it and design the initial starting of a mediation to avoid those triggers coming up. And as we are going throughout the mediation, I'm constantly watching for signs with a claimant. And it's primarily the claimants that I'm dealing with that have these issues, although every now and again I have seen them in defendants' lawyers as well. But let's just talk about claimants. I'm constantly watching for signs that they may be starting to move into that fight-flight stage. Now, that could, for some people, it can be excessive yawning and tiredness. They might be starting to sort of become into a hypoarousal phase, whereas the more obvious signs of people getting angry and agitated and fast breathing and twitching hands, those sorts of things, they're moving into a hyperarousal stage. Whichever stage they're in, it's a sign to me they need to be brought back into this sort of window where the prefrontal cortex and the sort of more survival part of the brain are a little bit more balanced so that they can engage in the process and just understand what's going on and understand the advice and feel confident to make a decision to resolve the claim or a decision not to resolve the claim, whichever they may be. So that's sort of the high level basis. There's micro steps throughout a whole mediation where I'll be drawing on parts of those trauma-informed principles. So, for example, one of the sort of general pillars is that for somebody to feel a sense of collaboration in how the process is moving forward. And sometimes that may be that they want the choice to be involved in and hear and understand the details of the defence arguments that are being put forward in great specificity sometimes. Sometimes they want to say, no, I don't want to be involved in that. Or sometimes they may want to have a specific engagement in exactly the wording of their final position that's being put forward at the end of a mediation. Sometimes they might I include people in every step of the way. So for me, my time with a claimant before we even get to an opening session is often longer than it would be if I was doing a standard workplace injury claim.
Let's take the example of the claimant. Because the claimant lawyers are so central in terms of the way they see the process as well, and they've got, their own professional reputation and, understandable issues around ego and those sort of things that mediators see a lot of. Do you find on the point of cultural change that in the legal profession there is a better understanding now? And is there more collaboration with you as a mediator, or do we still have work to do?
We've definitely got work to do. I think there's a bit of fatigue at the moment. I think we're sort of 10 years post-Royal Commission. The volume of the work that is coming through presents a huge amount of challenges for the lawyers, both claimants and defendants' lawyers, to manage the workload. There is absolutely some brilliant both plaintiff and defendant lawyers that really understand trauma. They really understand what trauma-informed means, and they work with me very closely. There are some that do not do it at all and just treat it as exactly the same as though it was a motor vehicle claim, whether it's abuse, compensation to real. I mean, I've seen in one of my nervous shock mediations, a claimant's lawyer was describing the death of a person's baby, and she kept referring to the baby as the deceased. And just something as little as that was just very offensive for her own client. She just hadn't thought about that because she was doing her job. That barrister was doing her job. She was being an advocate. But doing the job also entails acting in the best interests of your client. And if every time you're describing your client's deceased child as the deceased, that was causing psychological distress to that claimant that was in addition to the distress of actually having to go through a legal process.
I tend to agree. I think that I've seen some improvements, and on that point you raise, like the whole idea of acting for someone is to bring them with you. And so things like that really matter, how you address, because you really don't want to get in anywhere between yourself and your client in such critical, high stake environment of a negotiation. So on that point, there is some increased awareness, but there's more work to do, is a fair summary of where I hear you're coming from. What would you recommend to lawyers in both the plaintiff and the defendant space as a good place to start? Because I've had a look at this myself in terms of a trauma-informed training process.
Australia's got a long bit further to go than some of the other countries around the world. There is a training program or an accreditation program run by the Law Society of Scotland, which I think is excellent. I have done a lot of my own training and investigations and readings and research in the lead up before I actually found that accreditation program. And that accreditation program probably encapsulates everything that I had learned in my own self-reading in the 5-10 years before that. There is now an organisation called With You, which is Australia-based. They have a great online program as well. So I think that's an excellent place to start to learn a little bit more. I do lunchtime sessions and so forth, and I'm in the process of designing an online learning module for people about what trauma-informed mediation is. But I really think that Law Society program or accreditation program, it does mean you have to do training at 11 o'clock to 1 a.m. in the morning, which is hard, but I think that's an excellent place.
Yeah, I know that's where you did your training.
Yeah, it is. But I think there is actually becoming more and more materials out there where you can actually get a bit of an understanding. I mean, I've written a piece, I've published a piece in a magazine, an online Mediate magazine, about what a trauma-informed mediation is. There is now becoming a lot more research that's out there. So very simple searches may very well get you quite a lot of a decent understanding, but my high recommendation is that Law Society in Scotland course.
When we release this podcast for people, I will put out in consultation with you some of the training programs that you see in the market, because I think that's really useful. I've certainly been looking at it myself, and I think I had the conversation with you. It jumped out at me. What is the go-to training course for lawyers in this space in Australia? And to be frank, I was sort of looking around a bit. So on that point then, we talked at the high level about how you create the space, how you approach the level of empowerment, as I heard it, and collaboration. Have you done anything else in a more novel or innovative way? Because a lot of work as a mediator is very much thinking on your feet, that you can give us an example of.
I'll give you one example of a mediation not that long ago. It was a lengthy mediation. We had been going, it was in a historical abuse one, somebody who is a very vulnerable claimant. We're pretty much getting to crunch time of the mediation, and she was particularly agitated and she was having problems sort of even stringing sentences together. And I just said to her, look, would you like a break? Why don't we just take a breather? I can make you a cup of tea or something along those lines. And she said, I'm just exhausted. I could just do with a nap. So I said, okay. I went and spoke to the other side and said, can we just take half an hour adjournment so she can have a sleep? So defendants were fabulous, very, very good defendants firm that was involved in it. And they said, yeah, absolutely, we can do that. She slept for 2 hours. And the thing that was really encouraging with both her own lawyers and the defendants' lawyers, that when I kept going back to them and saying, I would really like to stay here and keep talking when she wakes up, because I don't want her to wake up and think it's all over and then she might feel as though she's made a bad mistake by trying to sleep. Can we just persevere and see how long she sleeps for and see how it goes after that? And to both parties' legal representatives' credit, they agreed with that. They actually also agreed to go away and do their own work until I contacted them again, so that it wasn't going to cost the parties any additional time. And I did the same. I sort of stopped the clock for the period of my mediation time. And when she came back 2 hours later, she had actually got herself back into a state where she could give some sensible instructions again. So doing that was somewhat unusual, to sort of stop and get everybody to pause while somebody's sitting in a boardroom sleeping. It's probably one of the more novel ones that I've had recently. But I've also had plenty where I've designed the layout of a mediation room if they want to have a joint session in a particular way. I moved some of the artwork that was in one of the boardrooms. In a particular case, I'd read in some of the clinical notes that this particular claimant, when he was going to have a really bad nightmare, the nightmare always started off in black and white. And when I walked into the boardroom, beautiful photos all around the boardroom, but they were all in black and white. So for that claimant, I knew that he would walk in and see black and white imagery all around him, and there was a potential that that could make him automatically start shutting down because he would think this is the beginning of something bad. So we just took all of the paintings of prints off the wall, moved some around so it didn't look quite so obvious. But just being aware that there may need to be things done like that. You need to, as you say, think on your feet, be flexible, and be very present in the moment. Somebody once said to me, "Isn't that exhausting?" And I said, "Well, yeah, it can be, but I'm being paid to create that environment, and my role involves looking at every possible barrier that may get in the way for sensible and meaningful discussions between the parties." And if it's not one of those approaches to mediations where you might see a barrister or a mediator reading the newspaper and taking offers and going backwards and forward, you have to be highly attuned.
Yeah, they're both really great stories, Julie. And it goes to the latter story, really goes to your attention to detail and really understanding the nuance and being really sensitive to the space you're creating. You talked about fatigue, and I don't have nearly your level of experience. Probably in my case, it's work that I want to do more of, but I've done about 5 or 7. And I see that, as you say, the lawyers being very fatigued. And for me, what I found as difficult as the allegations that were the subject of the claim was often the backstories even before you start to that point, like the trauma of people's earlier childhood. I found that quite difficult. And this is someone, again, who doesn't have anywhere near your level of experience. How do you personally deal with that aspect, vicarious trauma and your own wellness and presence, particularly when you spoke in the beginning about the critical nature of presence as a mediator?
Yeah, it's something that I constantly have to work on. I've sort of clocked up, I think, about 1,000 mediations now in this space. And I agree entirely with you. It's reading the totality of the materials that sometimes can be very confronting. I really focused on the importance of my own self-care. It only really landed for me when I did a week's conference at Oxford about 18 months ago on trauma. And a big component of that, and also the Law Society of Scotland course, was being aware of the potential for vicarious trauma and compassion fatigue. So I've now really accepted that my response to the materials I read is not a sign of an individual weakness or a sign of me not being able to be a good impartial mediator/lawyer. It's just biology. It's just the way the brain works. So I need to make sure that the rest of my whole well-being is also well balanced. So you have the fundamentals like your diet and exercise and sleep and community. I sort of see those as non-negotiables. They need to be there all the time. And now I'm much happier with making space for those because I know that they are my foundation. In addition to that, I do regular check-ins with myself. So about 18 months ago, I sat down and prepared a table of what is a sign for me physically, emotionally, spiritually, relationally with friends and family, that everything's going really well. So I have a column of my green behaviours. So they may be, I'm actively engaging in exercise, I'm not drinking every night when I get home from work, I still communicate with people and have very engaged sort of socially and physically. Then I have some amber ones and I have some red ones. So for me, for an amber sign, for example, is I'm picking online shopping rather than going to the gym. So I've created a table. Once a month, I have a diary entry that I go and look at that table and I just reflect on my behaviours for the previous week and think, where are my behaviours? Am I seeing more amber behaviours than green behaviours? And that means I get an alarm bell to myself beforehand. Hang on, things are starting to take a bit of a toll. Now you've got to double down on those foundational factors. I also have become a lot better at just doing micromanagement skills like deep breathing, a presence awareness throughout the course of a mediation. I've now got this rule when I'm moving between mediations that I don't walk up Martin Place checking my phone and returning phone calls. Whenever I'm walking up Martin Place, I'm just doing deep breathing. I'm just feeling the air coming in through my nose and out through my mouth. And all I'm doing is just trying to balance my sympathetic and parasympathetic nervous system. And I'm doing it when I'm not stressed, so that when I am really stressed, I can do that quickly, and it means it's like muscle memory. My whole body can just relax again. And I go, no, it's okay. I've got this. So it's regular check-ins on a monthly basis and micro check-ins throughout the day.
I love the rigor of your check-in process and how you've delineated the behaviours that, and if you like, seeing where it could go off track, which is fantastic considering the volume of work you do in that space. For me, the idea around wellness was a precursor to that was my leadership role and ensuring that if I needed to turn up as a leader, I needed to manage my presence more broadly, and that brought me to meditation and breath work and my exercise and social routine with friends. So I'm going to think about that, Julie, in terms of whether I could track. I did, for example, notice with a very disengaged but amazing 18-year-old son of mine last week after I did 2 institutional abuse, that I was just a little bit shorter about aspects around him that I would otherwise understand his teenage brain a bit better. So, yeah.
What I might do, Damien, is I will send you my table, a template of the table, and you can put it in the show notes just with that green, amber, red that I use, and people can download it and fill it out for themselves.
I think that would be amazing. And I think for practitioners in this space, on both sides of the ledger, that's a really useful tool. So thank you so much. Julie, thank you for your support of me as a newish mediator and the work you do. And I love the fact that you're in this space to create a level of cultural change. And that is a work in progress. And I really appreciate it. I would look forward to seeing more of you. I hope one of these days to maybe shadow you and see your approach, because I was speaking to Queensland practitioners who've had experiences in New South Wales, and a comment someone made is we could be doing things a bit better. Queensland was actually early adopter of mediation, but perhaps we've got to keep moving the pendulum, like in anything, I suppose. Change is not easy. So thank you, Julie, for your time, expertise, your honesty. Look forward to staying in contact. All the best.
Pleasure. Thanks, Damien. It was great chatting.
Thank you.